speech, Ms. Cruiser said one thing that I agree with, and that is that no man is above the law in our country. Now, you may be surprised to hear me say that, but the reason I agree with that is because we need to think about what does it mean to truly be above the law. And what I'm going to do in this speech is look at 3 specific consequentialist reasons why the Supreme Court's opinion would not end up harming our nation's balance of power. And what I'm going to do in the course of that is also respond to the arguments that have been brought up by the opposition. So the first consequence that would come from prosecuting presidents for their official acts is that it would allow Congress to unconstitutionally intrude upon the executive branch. So we need to think about what does it mean to be above the law. The law doesn't come from the clouds, it doesn't drop from the sky. Law is made, as Professor Domino said, by Congress. And law is an imposition of behavior made by bodies that have the power to impose those behavioral restrictions. And so what we need to ask is what power does Congress have to pass behavioral restrictions? So what we want to talk about here is that the Constitution has long been read to give Congress, to give the President a sphere of authority that Congress simply can't reach. Professor Domino talked about the fact that we don't have a parliamentary system of government. We have a system of government with a separate and unique executive branch. And it's long been held that the President does have certain powers that Congress absolutely cannot regulate. As early as Marbury v. Madison in 1803, the court said that the President has certain powers for which he is accountable only to the public and to his own conscience. If we look at the case of Mississippi v. Johnson in 1866, the court found that it was unable to enjoin presidential actions and the performance of his official duties. It couldn't tell the President what he could or couldn't do. It can tell lower officials, but not the President himself. And we talked about the case of Nixon v. Fitzgerald, where the court found that even though other executive officials can be sued, the President himself cannot be sued. So the point here is simply this, that the question before us is, does Congress have the power to pass criminal prohibitions against presidential acts when the President acts within a sphere of authority that the Constitution has designated only to him? The court said no, and this is in line with the long strand of judicial precedent. To completely eradicate this would be to allow Congress to legislate and to regulate even core areas of presidential conduct, which has been long held to be beyond Congress's power. But the second negative ramification that would come from denying presidential immunity and allowing Congress to fully criminalize every area of presidential acts is that it would create an unending cycle of retribution. And Ms. Cruiser expected that I would bring up this point, but I want to go back to what George Washington said at the very beginning, or at his farewell address after he left office. He said that the nation needs to be cautious of the alternate domination of one faction over another that will be sharpened by the spirit of revenge. Now, Professor Borey spoke about this being mere speculation, but Patrick Henry said that he had one lamp by which his feet were guided, and he said that is the lamp of history. In his words, I have no way of knowing the future but by the past. You know, if we look at the past and specifically look at how this has gone when other countries have gone down the path of prosecuting ex-presidents, we see it has been a dark path indeed. You know, I could talk about Peru, I could talk about Brazil, I could talk about nations in Africa, but for the sake of time, I'm going to focus on one nation in particular, the country of South Korea, where it was reported that half of all living South Korean presidents are currently incarcerated. If we look at the current president of South Korea, he rose to office in a wave of populist support because he prosecuted a former president. But political reports said now that he's in office, he's both concerned about being prosecuted himself and he's investigating his chief political rival. But this couldn't possibly happen here, right? Well, before the Supreme Court opinion came down, it already was. Let's start with the very first case against President Trump that came down in New York. Alvin Bragg, the district attorney in Manhattan, was elected on a campaign where he said that he boasted about his track record of having, in his words, sued President Trump over 100 times. He was elected and fulfilled his campaign promise by bringing charges against President Trump that, in the word of CNN legal analyst Ali Honid, were obscure and almost entirely unprecedented. And we could look at the federal cases as well. If we look at the timing of them, it seems highly suspect, because 3 days after President Trump announced his re-election campaign against the incoming administration, that administration announced it was appointing a special prosecutor against the president. Now, if we say this is only going to apply to presidents who truly commit crimes, like concealing documents. This isn't going to become a spiral effect. We can see that it actually already was becoming one. President Trump said shortly after these indictments came down, he said, now that the seal is broken, I will appoint a special prosecutor to go after, in his words, the most corrupt president in our nation's history, Joe Biden. And not just him, but those around him. A UC Berkeley law professor called for the retaliatory investigation and prosecution of Democratic officials by Republicans in response to President Trump's conviction. Now, this is what's interesting about the South Korean parallel. The political reports that in South Korea, when the first president was prosecuted, it was seen as a Democratic win, but it has since spiraled into an unending cycle of lawfare, where each side attacks the other. So we've seen this happen before. It's not speculation. And the Supreme Court's opinion put a stop to this by protecting the exclusive power of the president. The third disadvantage, or that would come from prosecuting presidents for their official acts, is that it would lead to an ineffective, timid, weak executive branch. You know, if we look back at how the founders designed the executive branch to operate, Professor Bory spoke about Federalist 70, and he said that it was just worried not about a president's strength, but about his effectiveness. And I would say that it was worried about both. It said in Federalist 70, Hamilton wrote that a feeble executive applies a feeble execution of the government. If we look at Federalist Paper 51, James Madison spoke about the concern that in a country such as ours, the legislative branch would overpower the executive branch. He said the weight of the legislative authority requires that it would be divided. That's why we have a bicameral or two-body legislature. And the weakness of the executive requires that it be fortified. The founders were also concerned about having a weak executive and an overpowering Congress. So the concern here, as Professor Domino explained, is that Congress would overpower the president to the extent that when he has to make split decisions, because the president is the most powerful person in the United States, if not the world, is faced with scores of decisions at any given moment, some of which do need to be made very quickly and concern integral national security issues. The concern is that he won't be able to make those in a way that he feels is just and right, because there will be concern about prosecution. Again, let's look back at South Korea. This isn't mere speculation. It was reported by people on the ground in South Korea that since the cycle of prosecutions began, the leaders in South Korea are terrified, in their words, that they are defensive, and that the government of South Korea, which used to be more efficient in other countries, has since ground to a halt. Now, the argument might be that, well, only presidents that have truly committed egregious crimes will be worried about it. Why would you be worried about your actions if you're not committing a crime? But the problem is the law isn't that simple. Attorney General and future Justice Jackson, not the incumbent, wrote in 1940 that the law is so broad. He said in his words, he said, quote, "With the law book filled with a great assortment of crimes, a prosecutor stands a fair chance of finding a violation on the part of almost anyone," end quote. For example, let's look at what the Supreme Court pointed out about a statute that is currently being charged against President Trump at the federal level, Section 371, which essentially, in the Supreme Court's words, criminalizes a conspiracy to impair the effective functioning of government. Now, what does that mean? The Supreme Court pointed out that almost every president is accused of impairing the function of government in some way or another. So if we have a retaliatory cycle of prosecutions where a prosecutor can search for any misstep based on any convoluted statute that the Congress can pass to regulate the president's unique Article 2 authority, then the president will be very restricted in the exercise of his functions. Now, I want to talk about some of the hypotheticals that Ms. Cruiser brought up. She brought up the idea that under the Supreme Court's opinion, the president will be able to stage a military coup or assassinate a rival. Now, Professor Prakash of UVA School of Law, who's no fan of this opinion, nonetheless recognized that the sky was not falling. He pointed out that the president does not necessarily have full control over the military because Congress can pass regulatory rules, it can control funding, it passes laws of warfare. And so that being said, there's no indication that this case, which we're debating today, not future hypothetical cases down the line, would prevent the president from being prosecuted for those acts. Let's look at bribery. Well, the issue with bribery statutes is that bribery statutes criminalize the agreement of to take the bribe, not the official act itself. So bribery would still be prosecutable under this opinion because you could show evidence of the agreement to take a bribe. And as for the idea that you can make a public statement to say that you're going to take out a political rival and that couldn't be brought in. The Supreme Court explicitly said in its opinion that public records can be referred to. So there would be nothing prohibiting the prosecution from bringing forth public records of the president. So in summary, we have a 235-year-long tradition of not prosecuting presidents. It's in line with our constitutional structure of having a unique scope of authority that is confined to the president and that other branches cannot reach. We've seen what happens when we go down the road of prosecutions. Even when these start out in good faith, they inevitably end up in a cycle of venomous rivalries and vengeance, as George Washington warned of. And we've seen what happens to the strength of the executive. The executive is eviscerated and withers. So for these reasons, I would strongly urge a no vote. The court did not give Trump too much immunity. It gave him the proper amount. Thank you.